Mr. Martin?
I am the living man. I'm not a, I am a living man known by the name of that.
The cases. This is your motion, sir. Go ahead.
So have you read the motion already?
Yeah, I've read the motion. I'm just asking you, are you standing on, are you just going to stand on the motion that you filed, which is fine, you can do that. I was giving you the opportunity to make oral argument if you wanted to.
Right. Well, just first I want to say on the so-called charge against me, I am entering a special appearance. Okay, that is in no way a general jurisdictional granting appearance. I challenge the jurisdiction of this court. The contract that I have knowingly, willingly, and voluntarily entered into with this court that grants any jurisdictional authority over me as a living man. If there's any such contract with the court, I demand the court present it. I also want to say I'm here by threat and duress. I'm not here willingly. Like I said, threat and duress, the normal. If you don't show up, arrest warrant, etc. Now in response to what to say about the motion. And the reason, first I want to point out the reason I don't like using the word motion, because I know that tradition. I use the word demand because it's based on the Constitution, right? My human rights. So how I've been taught in the law, these are the words I like to use. If I use the word request motion, that's not right, because you request privileges. You demand right. That's how I've been taught. So that's how I learned. So I just want to say that, I don't want you to take it personal or nothing like that. Hopefully, it just demanded my right. But I want you thinking, hey, I'm the judge here. Who are you to demand? But it's demanding rights. But anyway, so again, it's based on my right to private property, my due process, which is in the due process of the Michigan Constitution. No state law that they are trying to use, have wrote up about it, justifies my Constitution. And to do is try to use state statute, unconstitutional state statute law. But that doesn't justify my private property. Why it didn't justify depriving me of it then, and not continuing to deprive me of it now. I do not need to pay no money for it back from the towing place. And there's no injured party now in the case. I want to mention that too. So the plaintiff has no standing against these so-called criminal charges. There's no standing because there's no injured party. And I have a U.S. Supreme Court case on that, so I'll move to dismiss the case on that. Standing is a necessary, this is word for word U.S. Supreme Court case called Ramies versus Byrd. Standing is a necessary component of subject matter jurisdiction. Then we go to another case. The requirement of standing, however, has a core component derived directly from the Constitution. A plaintiff must allege personal injury barely traceable to the defendant's allegedly unlawful conduct. I can't think of nothing else to say now. I reserve anything else to say, though, if anyone else has something to say. If there's any dispute that it's not my private property, I'd like to hear that. And that's it for now.
All right. Mr. Greco.
Yes, addressing each of the requests here, which I believe are a motion to dismiss the charges and the return of property or wrongfully impounded moped. Your Honor, the defendant has been charged with driving while license suspended, revoked, or denied upon information and belief. And looking at the record, it looks like it's revoked. He was operating a moped June 11th, 2023 in the city of Taylor. When he was pulled over by the officer, he was unable to produce a license that he had, or if you are under a certain age, but up to a certain age, I believe it's 15 or above, you can get, if you don't have a driver's license, a special moped driving permit. But the charge is appropriate, and therefore the motion to dismiss with respect to the charge should be denied. Number two, with respect to the impound, here we have a driver who's not able to operate what is classified as a motor vehicle under the motor vehicle code, this moped, and it's on the side of the road. We can't keep it there. He can't take it. He can't drive it. For safekeeping more than anything else, it gets impounded. At that point in time, Mr. Martin is able to go get the moped if he wants. Yes, he has to pay for it because it has to get taken into custody because we can't just leave it on the side of the road. So we request that the motions be denied in their entirety.
I have something to say in response to that.
Sure.
I wasn't required to have any license, as I pointed out in my demand for dismissal of the case, because as the federal statute I've mentioned, first let me mention the state statute. It defines a motor vehicle as one just mechanically drawn. The Michigan state statute is unconstitutional, and 31 subsection 6 and 10 makes it clear the definition of motor vehicle by the federal statute is one mechanically drawn and used to passenger property for profit, which I was not doing. They do not have evidence that I was doing that, because as the U.S. Supreme Court said in the cases I cited, that the people have a right to travel. This is a long recognized right. Constitutional under the Due Process Clause, the right to life, liberty, or property. That's one of the liberties we are entitled to. A right, not a privilege. We need to request the DMV for as a book lawsuit to make changes because of this. So cops are not relying on this, and people stop being harassed. No state shall convert a liberty into a privilege, license it, and charge a fee therefore. Murdoch versus Pennsylvania, I relied on this case also, but this is what's going on with the state statute. See, they're assuming everyone's driving a motor vehicle or not. See, there's a difference between a motor vehicle, which is just one used commercially for profit, such as a DoorDash driver, a taxi driver. That's when you're technically driving a motor vehicle. When you're not doing it for profit, which is what I was doing, going to Walmart or Joyride, whatever I want to do, go to work, that's not for profit. That is what's called traveling, and this is terminology from the U.S. Supreme Court themselves, along with other law mentioned. It's called traveling in my private property. One of the legalese tricks, whoever excuse my terminology, whoever the scumbags was that made this stuff, because I think it was intentional. It's an intentional evil plan with this, so the average person don't know what's going on. It's a shame. Sum it up, I'm all within my right to travel. It's stealing my personal property. The state statute cannot justify stealing my private property. Finally, Greco did not respond, and therefore waived his response to my no injured party defense. That'll be it now. I reserve my response back to anything he may say that I haven't said already.
I've heard from both parties. Mr. Greco, was there anything further?
No.
So, Mr. Martin, through your oral argument and written briefs, you've raised a couple of issues. So let me address those seemingly in the order in which you raised them. Now, you argue that this court lacks jurisdiction over you. The question of whether a court has personal jurisdiction over a party is a question of law. And that can be stated in Poindexter versus Poindexter, and that's 234 Mishap 316, 1999. Typically, a plaintiff bears the burden of establishing jurisdiction over a defendant. However, a plaintiff here, the prosecution, only needs to make a prima facie showing of jurisdiction in order to defeat any motion to dismiss based on a motion to dismiss for lack of jurisdiction. Before a court can obligate a party to comply with its orders or proceed to trial or do any of these proceedings, the court must have personal jurisdiction over a party. I think we all agree that that's true. Jurisdiction over a person may be established a couple of ways: by way of general personal jurisdiction or specific or limited personal jurisdiction. So exercise of general jurisdiction is possible anytime that the defendant comes in contact with the forum state or the forum city or the forum body of government in such a way that the nature and quality are to enable a court to adjudicate any action against the defendant, even when the claim at issue does not arise out of contracts with the forum. Here, basically, it states that the existence of any of the following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of this state to exercise general personal jurisdiction over the individual or his representative, and to enable such courts to render personal judgments against the individual or representative. They point to three things specifically that I want to raise. One, presence in the governmental unit or city at the time when process is served, domicile in the city, and consent. In the present case, Mr. Martin was physically within the boundaries of the city of Taylor at the time of the alleged criminal activity, when he was served with the ticket. Second, Mr. Martin is also domiciled in the city of Taylor, which means he lives in the city of Taylor. The city of Taylor has ordinances regarding basically everything that the state does, and one of those is that you have to drive with a license. So I do find that there is personal jurisdiction over you. You availed yourself of the use of the streets here in Taylor. You live in Taylor, and you were served in Taylor. Therefore, you fall under the jurisdiction of the Taylor Court here, which is the 23rd District Court. As for standing, standing is a legal term which basically determines whether a party can bring a lawsuit or has a right to do so. Standing is not about the issues. It's about who is bringing the lawsuit and whether they have a legal right to sue. So if you are suing your government, if you have no damage, if you have no harm done to you, why are you bringing a lawsuit? Here, this isn't about harm. This isn't about a civil suit. This isn't for some violation of rights. This isn't a claim for money damages because you weren't allowed to live where you want to live or marry who you want to marry or some other form of federal type of a situation that's a constitutional based or a tort based thing. This is a governmental unit doing their job under the Constitution to enforce the laws of their cities and states. The standing that they have is that they can show by preponderance of the evidence, they can show that there is probable cause that you committed, that there was a crime committed and that you committed the crime in the city of Taylor. That's all they need for standing. That's all they need is that, and along with personal jurisdiction. We've already established that there's personal jurisdiction. So as to your standing argument, there is no standing argument. As for abandoning the vehicle or impounding the vehicle, under Michigan Compiled Law 257.252A about abandoned vehicles, it specifically states a person shall not abandon a vehicle in this state. So if you are arrested or you are using something as the instrumentality for committing a crime, you have a right to a trial, but that evidence has to be preserved and they can't just leave vehicles laying around on the side of the road. It's for the protection of the evidence, and it's also for a protection for you because you can't just leave it on the side of the road, because I know it's hard to steal a car. But if a moped, someone could just pull up, throw it in the back of their pickup truck, and now you're without a moped. Then you might have a lawsuit against the city for not doing their job of having it impounded and protecting your vehicle, protecting your moped. That's why it's taken. Your moped is in safekeeping, and that's what they're supposed to do. So under the abandoned vehicle statute, they do have a right to do that when there's a crime committed. So now that brings us to our last point about the fact that you think that there's an underlying reason why this should just be dismissed outright. Laws that are set forth by the government. Driving is a privilege that a state can prohibit if they consider it. You do not have a constitutional right to drive a vehicle. You have a right, you can walk your happy self all over the state. You can Forrest Gump that thing all the way from one end of the country to the other. You can go ahead and jog your way back and then back again. You can't drive a vehicle if you don't have a license. I'm going to go to Florida. I'll give you a free, how about if I am, let's just say a hypothetical, I'm going to give you a free trip to Florida, Mr. Martin. All expense paid, and there's no air fees, because I have a private jet, but I'm the pilot. You going to fly with me? I've never even taken a class about flying a plane. Don't even have a pilot's license. But you know what? I got a right to travel. I'll fly a plane if I want to. Does that make any sense? No. Why? Because planes can crash and kill people. Planes can crash and kill people. Cars can kill people. We want to make sure people are licensed to drive vehicles. Why? Because you're interacting with other vehicles that weigh thousands of pounds that are moving at rates of speed 30 miles an hour and higher. There's literally a National Traffic Safety Administration. Why? Because it's a dangerous situation. Yes, we need it, and yes, it's necessary. But because of that, the driving privilege can be revoked. The right to drive a motor vehicle can be revoked. The right to have, trust me, I'm the most firm believer in the right to keep and bear arms. But if you're not mentally in the right state of mind, or if there's some sort of reason why everyone has agreed that, you know what, this guy should not be having any weapons. He's threatening to kill himself. You know what, for his own safety, let's get the weapons out of his hand. Now, the reason we have weapons, it isn't so we can go hunting. It's so we can protect ourselves against the usurpation by our despotic government of any of our rights. I get that. I understand that. But at the same time, I'm not going to fly in a plane with a pilot who's never even taken a class, doesn't have a license. And that's why driving is a privilege. It's based on the character and nature of the activity. Yes, you can travel. You can ride a bike. You can pedal yourself around. You can walk anywhere you want to. You don't need to show your papers when you're going from Michigan down to Ohio. Your papers, please. This isn't Russia, but you can't drive if you don't have a license. And so, based on all of those things, based on the oral arguments that were presented today by both sides, based on the written briefs and answers to the same, I am denying your motion to dismiss, and I am denying your motion for the return of the moped. So this case is going to be set for a pretrial. Since we're here, we're going to do an arraignment on the underlying charge. Mr.
No court-appointed attorneys, that will not be, they can fraudulently assume under the jurisdiction of the court. I invoke my right to be acknowledged as a sovereign, one of the sovereign people, as the U.S. Supreme Court said I have a right to do. Invoke my rights under the Republican form of government, Article 4, Section 4. So I won't be stepping no attorney.
Okay. So you do have the right to remain silent. Anything you say can and will be used against you at trial. Like I stated, you also have the right to an attorney. And at any point, if you'd like the assistance of an attorney, please don't hesitate to ask the court, and I will grant the same. It is alleged that on July the 11th of 2023, that you violated City Ordinance 3200B, which is commonly known and referred to as driving on a license that has been revoked. That's a misdemeanor punishable by 93 days in jail and or up to $500 in fines. As to that charge, how do you plead? Guilty or not guilty?
I'm not here to plead because I do not acknowledge myself as no defendant. That's fraudulent. I'm not a legal fiction.
Then I find you to, then I recognize you as standing mute as to the charge, and I'll enter a plea of not guilty.
Okay.
And we're going to set this.
So
we're not. Okay.
Have you entered a legal determination that I am not guilty of the charges?
Nope, I've just put in a plea right now at this time of not guilty, and we'll set this for a trial. The adjudication of your constitutional right to have a trial by judge or by jury, that will determine beyond a reasonable doubt if it's proven whether you're guilty or not guilty, pursuant to the Constitution.
Okay. I still have some things to say in response to what you said today. Yeah, so I have some responses in response to what you said today, such as, is it okay if I say it now?
Your response to
what you said today, after we made the argument, some things, I still have some things to say in response to that.
You're saying you would like to make a response to the ruling I made with regard to your two motions? There's no response to be made to it. I mean, if you'd like to make a record, you're more than welcome to file any motions that you'd like under the court rules. But that was merely my ruling as to two motions that were in front of me: the motion for return of the moped and the motion to dismiss. So, Mr. Greco, if you would put that in order.
I object to it, and I have some more to say about that, and that is,
what I'm saying, sir, hang on, because and I'm not trying to cut you off. I'm trying to protect your constitutional rights, because anything you say can and will be used against you. I just wanted you to be aware of that. Okay.
Yeah, I got
so what I'm saying is, I'm not gonna change the ruling today. If you want to file a motion for reconsideration, you can do that. You have the right to do that under the court rules.
Now, I might not remember everything because you said a lot of different things, and it might be hard to remember everything and respond, but I still got some things memorized I want to say now, so I want to say them. That is, you do also, and like I said, at any time, if you'd like a court-appointed attorney, I can give you a court-appointed attorney. But you could also order a copy of the transcript, so that way you don't have to remind yourself of anything. You can just, everything that was stated is already on the transcripts. That is, and they try to charge money again. Again, it's a big monetary thing. You know, it's trying to turn rights into privileges, charging money,
Well,
and I don't have money for that.
it's not about charging money. When I go to the store, I don't just get to walk out with bread. I mean, I got to pay for the bread because somebody made the bread. So somebody.
This case is a classic example of what happens when someone tries to use so-called sovereign citizen arguments in a real courtroom. Mr. Martin repeatedly claims that he is a living man, and therefore the court has no jurisdiction over him. He also insists that he never entered into any contract with the court, so the law does not apply to him. However, the reality is very different. The judge calmly explains that jurisdiction is not optional. If you live in a city and allegedly commit an offense there, you are automatically subject to that court's authority. It does not depend on personal beliefs or self-identification. The law is based on where you are and what actions you take, not on how you choose to describe yourself. Another major argument Mr. Martin raises is that there is no injured party, and therefore the case should be dismissed. But the judge clarifies that this is a criminal case, not a civil one. In criminal law, the government itself brings the case to enforce the law. There does not need to be a specific individual claiming harm for charges to proceed. Throughout the hearing, the judge listens patiently and allows Mr. Martin to present his arguments fully. However, each claim is addressed with clear legal reasoning. This situation highlights an important reality. Courts operate on established law and legal principles, not on internet theories or personal interpretations. In the end, this case demonstrates that confidence alone does not make an argument valid. What matters is whether the argument is legally sound. And in this situation, it clearly was not.
If there's to any comment that you state that I'm trying to railroad you or any kind of thing, because you know what? The Constitution is the most important thing to me. The Constitution is what gives every one of us freedom. Constitution is when I get woke up in the middle of the night to sign a search warrant. God bless them. God bless them. Thank you for waking me up in the middle of the night to sign a search warrant. You want to know why? Because that's the Constitution breathing.
The most interesting part of this case is the debate over the right to travel. Mr. Martin strongly argues that he has a fundamental right to travel, and therefore he does not need a driver's license. He even claims that a motor vehicle only applies to commercial use, such as taxis or delivery services, and since he was not operating for profit, the law should not apply to him. The judge firmly rejects this argument and explains the distinction in a very practical way. Yes, people do have a right to travel. You can walk, ride a bicycle, or move freely from place to place. However, that does not mean you can use any method you choose without following the law. To make the point clearer, the judge uses a powerful example. He asks, what if someone decided to fly an airplane without any training or license, simply claiming a right to travel? Obviously, that would not be acceptable because it would put lives at risk. The same logic applies to driving. Driving is considered a regulated activity because it involves operating a potentially dangerous machine around other people. Cars and mopeds can cause serious harm if not handled properly. That is why the state requires licenses to ensure that drivers meet certain safety standards. The judge emphasizes that driving is a privilege, not an unrestricted right. It can be regulated, suspended, or revoked depending on the circumstances. This distinction is critical and often misunderstood. This part of the case
Process. I gave you the benefit of the doubt of being someone who's improper. That's fine. Not a problem. I heard your motion. I allowed you to make oral argument on your motion. I afforded due process to Mr. Greco, where I allowed him to make a response on the record. I asked you right in the beginning, is there anything you wanted to say for oral argument, or did you just want to stand on your brief that you filed? And you went ahead and made oral argument. That's allowing you due process. This is all everybody playing the game. This is everybody doing their part and having the opportunity to play the game. And that's what I afforded every single individual. I take offense.
In the final part of the case, the situation becomes even more telling as the judge denies all of Mr. Martin's motions and moves the case forward to trial. Despite the ruling, Mr. Martin continues to argue, attempting to challenge the judge and even suggesting disqualification. However, the judge maintains a calm and professional approach, focusing on the legal process rather than the emotional tone of the exchange. One of the most important points the judge explains is the concept of due process. He makes it clear that Mr. Martin was given every opportunity to present his case. He filed written motions, made oral arguments, and was fully heard in court. That is what due process means, having a fair chance to be heard. It does not guarantee a favorable outcome. The judge also highlights the importance of procedure. Courts operate under structured rules, and decisions are not changed simply because a party continues to repeat the same arguments. If Mr. Martin disagrees with the ruling, he has legal options such as filing a motion for reconsideration or pursuing an appeal. That is the proper way to challenge a decision. This moment reinforces a key lesson. The legal system is built on order and consistency. It cannot function if individuals attempt to override procedures with personal beliefs or persistent arguments. Ultimately, this case shows that understanding the law requires more than confidence or repetition.